Good morning, everyone. Welcome to our TUPE Club webinar today. And we're focusing on TUPE in a restructuring or redundancy scenario for this particular webinar. And I think it's worth us emphasising that this is a result of your feedback. So we do really take your feedback seriously. And we hope this is going to be a really useful session to you, whether you're on the legal, operational or HR side of a deal. So this session is one that we're going to include both outsourcing and a business transfer issues, and they'll be brought out throughout the presentation. So moving on to what we're covering today. Firstly, I'm Siobhan Bishop. I'm a Principal Associate in the Employment team here at Gowling WLG, and I'm delighted to be joined by my colleagues. Firstly, Hannah Swindle, who is a Director in our team, and also Karen Keogh, who is a Senior Associate in our team. So you'll see from the agenda that we've set out how we're going to structure this, and they'll identify the key issues that you need to focus on in terms of a collective consultation process in a redundancy situation and how it links to a TUPE transfer. There will be some time to submit questions at the end, but please feel free to submit those as we go along through the Q&A button. And also, if you have any technical questions, we have Susie Barnes here to assist us, and she'll deal with any questions on the technical side, again, through the Q&A button. So we'll have an overview first of how to manage the process, and then how it differs, drawing out the difference between the TUPE information consultation process and the collective consultation process for redundancy. And look finally how to mitigate those risks, which can be quite significant. And hopefully we'll have some time for your questions at the end. So I'm going to hand over now to Hannah, who will deal with an introduction and put the whole issue in context.
Thank you, Siobhan, and good morning, everyone. As introduced, this session is about restructuring, and we're looking at restructuring in the context of a TUPE transfer and situations where the two elements are linked in some way. So we're going to pick up on a few example situations, looking at some of the things we need to be aware of when planning for these changes, and also some pointers as to how the connected processes overlap and interact. But to start us off, I thought it'd be useful to give a very quick reminder in the first slide, which sets out the situations where a TUPE transfer can apply. So this could be a business transfer style TUPE transfer, and this is defined as a transfer of an undertaking or economic entity which retains its identity. And here, all or part of an undertaking or business is going to be transferred to a buyer, the transferee. The other type of transfer is a service provision change. So this is where activities carried out by or on behalf of the client are carried out by a different party going forward. So it could be where services are being outsourced for the first time by a customer, or it could also be any subsequent outsourcing to a replacement supplier, or where the services or activities are then being brought back in-house by the client, which is often known as insourcing. I'm not going to look at the conditions for a transfer in any more detail today, but if you would like to learn more, I'd encourage you to have a look at our introduction to TUPE webinar, and that's available on our website. But for the purposes of today, we'll assume that all conditions for a TUPE transfer are met in the scenarios we're looking at. So, as I mentioned, we're talking about TUPE transfers connected with a restructuring or movement of staff within a group. So what sort of circumstances are we talking about? Well, restructuring is a general term which covers situations where staff are organised differently. But it can often involve a redundancy situation or downsizing. So, for example, after a TUPE transfer takes place, an incoming employer may want to make redundancies. This could be because the new employer needs to relocate a business or services to their own offices or their own site, or they may already have a sufficient number of their own employees to carry out the jobs that are going to transfer. Alternatively, it may be appropriate to carry out a reduction in the workforce before a TUPE transfer in certain circumstances. This may be more common in a first generation outsourcing or asset sale, where the client or the seller wants to look after its own staff and effect a redundancy process itself, with managers who know the employees being involved. This does lead me on to an important point quickly, that when making any dismissals, these will need to be done fairly to minimise risk. So it's important that whoever is making the redundancy takes into account both ordinary unfair dismissal protections, but also the additional protections provided to employees by TUPE, and we'll be highlighting that today. And also, if redundancy proposals involve 20 or more dismissals, then collective redundancy obligations will apply. And Karen's going to recap the main elements of a collective process for us in a moment. A collective redundancy process might also apply if there's a proposal to change terms and conditions for 20 or more employees, which involves dismissal and re-engagement. That's also known as fire and rehire. The protections given to employees by TUPE means it's harder to change terms and conditions where those changes are connected with a transfer. So this process can potentially be used by employers to try to ensure that any changes made are valid and enforceable. This process has featured unfavourably in the press in recent years, and I think as a result, it's fair to say that employers are more reluctant to carry it out now. But I wanted to mention it here to highlight that a dismissal and re-engagement will qualify as a redundancy for collective purposes, even though there's no planned reduction in the overall number of employees. We're not going to focus on this topic in any detail today, but again, we've got some further information available in one of our previous webinars. I've mentioned a share purchase in my list of examples. Of course, TUPE doesn't apply to a share sale or purchase, but sometimes there can be a less obvious connected TUPE transfer that parties may not immediately consider. Either before or after a share acquisition, there could be a TUPE transfer which is triggered by an intra-group hive up or hive down, so where employees need to be moved around into the right place within a group of companies. And this could be so that the seller gets ready for the sale of one of its companies, moving employees into or out of the target, or alternatively, after completion of a share purchase, the buyer may want to move employees around to integrate them into another group company. So where a TUPE transfer is triggered, this means that all of the rights and obligations associated with it will apply. And this includes obligations on both the incoming and outgoing employer to inform and consult. And Karen's now going to run through a reminder of the main points of that.
Thank you, Hannah. So as Hannah mentioned, we covered the obligations to inform and consult under TUPE in our last webinar, and that's available on demand. So again, worth having a look at that. But as a result, I'm also not going to go through any of this in particular detail, but I will just recap the main points. So where there is a TUPE transfer, both the outgoing and incoming employers will have duties to inform and potentially consult with appropriate representatives of their affected employees. So the duty to inform is the requirement to provide certain specified information to the appropriate representatives about the transfer, timing, and its effect on the affected employees. But the duty to consult kicks in where there are any measures or consequences that the employer envisages the transfer may have on the affected employees. But in reality, even where no measures are being proposed, case law does suggest that employers should look to consult in any event on a voluntary basis. And that's really to help the process run a bit more smoothly and potentially avoid employee relations issues. So in the context of a restructure, it's always important to consider whether a planned restructure or a step you might take in connection with it is a measure on which you need to consult. And that will often depend on the timing of the proposal and how certain the relevant party is that this actual step will happen. And obviously, it's also important to consider how much detail to give to employees about a particular step you propose to take in connection with the restructure, because there's very much a balance that needs to be struck. So, for example, you may anticipate that there will be a share acquisition post-transfer, in respect of which you might be under a duty to consult. But you may not want to or actually be able to disclose much to employees for confidentiality reasons. So there is a need to consider if the risk of not complying with the duty to consult could potentially outweigh the risk of breaching the confidentiality provisions of a potential share sale and vice versa. From a practical perspective, it's also worth flagging that if a share acquisition happens shortly after the transfer, then the employer may also want to consult on the buyer's proposed measures post-acquisition. For example, if there's going to be any changes to existing incentive schemes. And again, while that's not really a legal requirement, it may just help things run more smoothly. But obviously, in terms of how much information you share, there's also a risk in taking the opposite approach and oversharing about steps you may take in the future, because you may not actually be able to provide enough detail about what you're proposing and when, which could end up destabilizing the workforce and creating more employee relations issues in the longer run. So when we talk about the duty to consult, what we mean is that the duty to inform and consult is with the appropriate representatives. And by that, we mean either pre-existing trade union or staff council reps, or those that have been specifically selected for this process. But of course, there are some exceptions. For example, micro businesses that have less than 10 employees can consult directly with their employees. And for transfers that are going to be taking place on or after the 1st of July 2024, so next month in about 3 weeks, the requirement to elect employee representatives for the purposes of TUPE consultation will be removed, where either the employer has less than 50 employees in total, or regardless of the employer's size, there are less than 10 employees involved in the transfer. And in all of those scenarios, employers will be able to inform and, if necessary, consult directly with employees, provided that obviously there's no existing employee reps in place and the employer hasn't already invited any of the affected employees to elect employee representatives. Obviously, there are some practical things to think about. So one, this won't be applying to collective redundancy consultations. So if the measure is redundancy for 20 or more employees, then consulting directly with the employees would not comply with that duty. And I'm going to move on to that in a second. The other point to flag is that there may be circumstances in which consulting via elected reps may actually be preferable to individual consultations. So say if you have 49, 48 employees, if you go for individual consultation, you may have to have 49 individual consultations, whereas it may actually be quicker and easier to have a consultation with elected reps. So in terms of timings, how far in advance of the transfer do you need to start the TUPE consultation will largely depend on the significance of the proposed measures. So for example, a restructure or a redundancy process will definitely require more time than something more trivial or less impactful on the employees, such as a change to their uniform. And just to cover off risk, the penalty for failure to inform and consult is up to 13 weeks gross pay per affected employee. And that is joint and several liability that's shared between the incoming and outgoing employers, unless, of course, the sale contract apportions liability differently, which is often the case. And before I move on to collective redundancy consultation, I just thought it'd be worth flagging that there is a special circumstances defence. So it's possible for an employer to defend a claim for failure to inform and consult, where it's able to show there were special circumstances which meant that it was not reasonably practicable to comply with the duty to inform and consult. But this in reality is a really narrow defence, so it's not one that we would recommend counting on. So having whizzed through TUPE information and consultation duties, in any restructuring or redundancy process, you also need to check whether it triggers the collective redundancy consultation requirements. So worth flagging that that's additional to any other employer obligations. And the duty is triggered where you're proposing to dismiss as redundant 20 or more employees at one establishment within a 90-day period. The term proposing to dismiss means that there must be more than a mere contemplation of the possibility of redundancies, but it's before an actual decision is made by the employer to make redundancies. And of course, the meaning of redundancy in this context is broad. So, for example, it could be triggered by a proposal to fire and rehire 20 or more employees to implement a change in contractual terms, like Hannah mentioned earlier. So, if the duty to collectively consult is triggered, the employer is under an obligation to, 1, provide certain information to employee representatives, and 2, consult with them about the redundancy proposals. So the obligation to provide information is quite similar to the requirement to inform under TUPE. And there is a list of specified written information which must be given to the appropriate reps, and it includes things like reasons for the proposals, numbers and descriptions of redundancies, and calculation of redundancy payments. The key point, though, is that the information must be sufficiently detailed to enable meaningful consultation to take place. And employee reps must also be given a copy of the HR1 form, which the employer will need to file with the Secretary of State. So, as for the subject matter of the consultation, it has to cover off certain points like how to avoid the dismissals, reducing the number of dismissals, or mitigating the consequences of dismissals. And the key point is that the consultation must be with a view to reaching an agreement. But what it means is that the employer has to be open to ideas provided by the reps and genuinely consider them. But the reps can't actually veto the redundancy proposal, so ultimately the redundancies can go ahead. But of course, it is important for the employer to show that they've got an open mind and that they're willing to be persuaded, because ultimately the purpose of the consultation process is to achieve an agreed solution with appropriate representatives. So a question we often get on collective redundancy consultation is timings. And there's actually no fixed period as such for how long the consultation has to take place. The key is that it has to begin in good time. But there is a requirement that dismissals may not take effect before the expiry of a minimum period of 30 days. And that's increased to 45 days if 100 or more employees are affected. So the effect of the minimum time period is effectively to be a moratorium on dismissals whilst consultation is carried out. So it is possible for employers to give notice of termination during this period, as long as the expiry of the notice takes place outside of the period. In terms of risks, the penalty for failure to collectively consult is separate to any penalty for failure to inform and consult under TUPE. And the penalty is a maximum penalty of up to 90 days gross pay per employee. There's no cap on weekly pay either. Of course, it is worth flagging that if an employee is dismissed, there may be additional employment obligations, such as the individual consultation process and the obligation on the employer to look for suitable alternative employment. So the protective award that I've just covered off is additional to any other award that may be made for unfair dismissal. So in a very similar way to the failure to inform and consult under TUPE, there is a potential defence to a protective award known as the special circumstances of defence in a collective redundancy consultation context. But again, as with the TUPE defence, the circumstances have to be special, and even then the employer still has to take all steps as are reasonably practicable in the circumstances. So it's really important for employers to do whatever they can to comply, even when facing extreme timescales. And actually on that point, even in an insolvency situation, that in itself will not be a special circumstance, and the employer still has to do whatever it can to limit any potential penalty. And before I hand back to Hannah for the next slide, I thought I would just flag that a statutory fire and rehire code is expected to come into force next month, which increases protection for employees where the employer is proposing to vary their terms and conditions by firing and re-engaging effectively. The government also proposed that a failure to comply with the code should increase a protective award by up to 25%. But this proposal remains in draft form, and it's obviously worth flagging that if a new government is elected following the general election, this all may be subject to change. So very much a case of watch this space.
Thanks, Karen. So if we just have a look now at timing. So businesses will need to consider the right time to carry out any planned restructuring process and decide whether it's better to carry this out before or after a TUPE transfer. Sometimes there won't be any real choice about when a process or reorganisation has to happen, as other considerations such as tax or competition requirements will drive both the reason for staff restructuring and also the timeline. At other times, there may well be a choice. So what are some of the factors that may influence a decision? If a redundancy process is needed, should this be carried out before or after a TUPE transfer? And there's a number of things to think about here. So first of all, whose redundancy reason is it? So case law has confirmed that an outgoing employer cannot borrow or rely on the incoming employer's ETO or redundancy reason to justify the dismissal where you're connected with a TUPE transfer. If any dismissal is made before a transfer without an ETO or economic, technical or organisational reason, it will be automatically unfair for employees with 2 years service, and connected liabilities will transfer across to the incoming employer in the ordinary course. So I'll come on to how we might be able to manage some of the potential risks. In an asset sale or first generation outsourcing, does the outgoing employer want to manage the redundancy process itself, maybe for employee relations reasons? Maybe all staff are very long serving, or it might be worried about a reputational backlash if it doesn't manage the process correctly. Or it may be because there's an overall process involving staff that are going to be retained as well as the transferring employees. If a buyer or incoming employer needs to carry out a proposed redundancy process because it operates from a different location than the seller or outgoing employer, then there are often practical difficulties involved in carrying out the redundancy process post-transfer. The incoming employer might not have a physical location which it can use to consult with staff, and there are also cost considerations in terms of salary that have to be paid post-transfer. If the business is being relocated a significant distance away, for example, it might be the case that most staff are going to end up being made redundant. So here, a buyer might not want to carry the additional cost of a protracted consultation period post-acquisition, and they may want to start consultation pre-transfer to save time and cost. Alternatively, an incoming employer may need to actually take the time post-transfer to fully analyse the new business it has acquired before deciding how many employees and what roles it will need going forward to run it most effectively and efficiently. It might also need to make other changes, such as to pension schemes, which have their own minimum consultation period requirements, or it might need to make changes to terms and conditions overall. So all of this may involve a much more detailed and involved process. And as an employer, you'll need to think about that very carefully before launching in. If an incoming employer needs to pool transferring employees with its existing workforce for a fair dismissal, this might only actually be practical after the transfer, so something else that you might want to think about. The impact of other previous processes should also be factored in. Staff might have already gone through various consultation processes by the time you've got to this point, could be feeling vulnerable and insecure, which can all affect productivity and retention going forward. So an employer needs to consider the human aspect. So when is it going to be least disruptive to start to consult about another process? It may be possible to wait a while before having to start something new. It may not, but something again to consider. If there is to be a hive down of employees pre-sale or post-sale, a hive up to another group company, then there may be some flexibility in the timing of the TUPE transfer, with the employer being able to separate the transfer and the share sale with a longer period in between. And this may help suggest that the two processes are more separate. That might be helpful if the seller doesn't want to inform the workforce about the proposed final sale, as Karen mentioned. At other times, we may have factors that mean the two events need to happen closer together. So in summary, just a few things to think about there. Every case is going to be different depending on its circumstances, but there does need to be consideration as to when it's going to be best to start these processes.
Thank you, Hannah. So, as Hannah flagged, there are certain situations where it would be useful for an incoming employer to be able to start redundancy consultation before the TUPE transfer. And actually, historically, an incoming employer could not start collective consultation until after the transfer without risking claims for protective awards. And that's because the incoming employer will not have been the legal employer of the relevant employees until after the transfer. However, under the TUPE rules, of course, redundancies would be deemed a measure. So the employees could be left in a position where they're aware of potential redundancies from the TUPE consultation, but they've got limited information about it because the incoming employer can't start consultations before the transfer. And that could be a huge source of stress and uncertainty for the employees. And of course, it also meant that the incoming employer had to delay any dismissals until after the transfer, which obviously added time delay and increased costs. So thankfully, changes were introduced in July 2014 to allow incoming employers to choose to validly start collective redundancy consultation pre-transfer. So the changes effectively created a legal fiction because, of course, the incoming employer doesn't actually employ the transferring employees until after the transfer. But for the purposes of satisfying the duty to collectively consult, the incoming employer is treated as if they are the employer at the time of the pre-transfer consultation. So in practice, it means the overall period of consultation with employees can be much shorter, potentially less costly. And it also reduces the length of time employees have to live with uncertainty, which obviously can help with employee relations. But as you might expect, pre-transfer collective consultation can only be used in certain circumstances. So the circumstances are that there is or there's likely to be a relevant TUPE transfer. The incoming employer proposes to dismiss as redundant 20 or more employees at one establishment within 90 days. And at least one transferring employee must be affected by that process. So where all of those three conditions are satisfied, the incoming employer has the option to carry out pre-transfer collective consultation. But obviously, as you might expect, the process for setting up pre-transfer consultation is not entirely straightforward. So worth flagging that from the outset that it is the incoming employer's process, and they can choose whether or not they want to do it by way of a written election. But it's really important to flag that the process can't be forced on the outgoing employer because the outgoing employer has to give consent to it. And it's obviously always best to get the outgoing employer's consent in writing to avoid future disputes. So the incoming employer is very much reliant on the outgoing employer to facilitate the process, including by allowing access to employees and helping to elect any employee representatives. And the incoming employer has to also remember to complete the HR1 form and notify the Secretary of State of the proposed dismissals. Either the incoming employer or the outgoing employer can give the required information to the employee representatives, but it's very likely going to be the outgoing employer who's going to hold the relevant information, such as notice periods and enhanced redundancy entitlements. So there's a degree of heavy cooperation needed between the parties. And equally, care also needs to be taken to ensure that the appropriate representatives are put in place for the transferring employees. And again, the incoming employer may be heavily reliant on the outgoing employer's knowledge of the workforce for information about how many reps will be required from each area to ensure that all employees are adequately represented. So all of those things that I've just mentioned highlight, again, the fact that it is really essential to have cooperation between the parties to make sure that the process runs as smoothly as possible. And that's going to be key to determining whether it's actually going to work in practice. And there's no legal obligation on the outgoing employer to provide information or assistance. And actually, a lack of cooperation would not be considered a special circumstance, which would provide a defence to a failure to consult claim for the incoming employer. So there's quite a bit of risk involved. But to make sure that the parties do cooperate well, it's a good idea to enter into a cooperation agreement. And this will include the parties agreeing where potential liabilities would sit if things go wrong. For example, if the outgoing employer doesn't allow time off or access to facilities for reps. And the parties may also want to include protections for their confidential information, agree how the process itself will be run, the facilities that will be provided, and what access will be given to employees. And the parties may also want to allocate any consultation process costs between them in the cooperation agreement. It is also worth flagging that the outgoing employer can also face risks connected with this process, because the incoming employer can choose to cancel the process at any time. That can obviously cause disruption and potential employee relations issues, because any consultation done so far wouldn't count, and employees would be left until after the transfer before they know what's going to happen. And worth also flagging that if the process is cancelled, it can't actually be restarted until after the transfer. And of course, it's important not to forget about the need to consult individually before any redundancy dismissal takes place, because where employees have 2 years service, an employer will risk claims for unfair dismissal if that process is not carried out. And because the incoming employer doesn't legally employ the employees until after the transfer, despite the legal fiction that the collective consultation process has created, any individual consultation it carries out before the transfer is technically not going to count towards consultation for unfair dismissal purposes. And also, the pre-transfer consultation provisions do not explicitly allow the incoming employer to select individuals for redundancy before the transfer. And actually, ACAS has previously advised that employers shouldn't do this. So there are a number of constraints to think about.
Thanks, Karen. So following on from Karen's points, I wanted to flag a few more of the practical issues that can arise when using pre-transfer consultation and some ways of managing that risk. So as we've heard, any proposed post-transfer redundancies will be measures that need to be fed into the TUPE consultation process to avoid the risk of information and consultation claims. Using the pre-transfer consultation process enables the employer to be able to provide more information about proposed redundancies at an earlier stage, helping to reduce uncertainty. But it's important to manage the flow of information under the two separate consultation processes, which are likely to be run side by side so that there's no inconsistencies. So employers will need to map out how to run two similar but different processes, ensuring that the requirements for both are fully complied with. It may be appropriate to use the same reps for both processes, but if so, then the reps will need to have a formal remit to be able to consult for both, if that's the case. So if we have a pre-transfer dismissal, Karen has reminded us that the requirements to carry out a full individual consultation process before making redundancy dismissals can cause risk for the employer of unfair dismissal claims if this is carried out pre-transfer, because they can't rely on it. So even if the incoming employer actually effects those dismissals after the transfer, if the individual consultation has gone on before, then it can't rely on it, and that results in risk. A pre-transfer consultation process also results in issues around pooling and how selection can be made fairly. But if we've got dismissals being carried out by the outgoing employer pre-transfer, so doing its own individual consultation, this also is not going to solve the problem. It's not going to remove risk, because if they affect the dismissals, they may not have that ETO reason, that economic, technical or organisational reason. So if the redundancy reason belongs to the incoming employer, the outgoing employer can't use it. Any dismissal in a TUPE transfer situation without an ETO reason can result in an automatically unfair dismissal. And we've heard that associated liabilities connected with that would legally sit with the incoming employer. So pre-transfer dismissals are still risky, but sometimes they can't be avoided and they need to take place before the transfer. So to remove the risk of claims of either the automatic or ordinary unfair dismissal, redundancies should be made under a settlement agreement where the employees waive their rights to bring a claim. This will need to be a tripartite agreement so that the incoming and outgoing employer can both take the benefit of the waiver. And just as a quick reminder there, it's not possible for an employee to legally waive their rights under a settlement agreement to bring either a collective consultation claim for redundancy purposes or a TUPE informational consultation claim. It can be validly done through ACAS, but this potentially introduces a lot more complexity into the situation, which might not be practical or appropriate. And just as a practical point where we are carrying out this pre-transfer consultation, to avoid any confusion or duplication, the parties should agree in the cooperation agreement, if possible, when and who is going to give that notice of dismissal right at the outset of the process so that all communications are clear and that the employer can give the employee the right messages. Another practical problem might arise if the collective redundancy process has not concluded by the transfer date. So there could be a scenario then when the representatives who are being used for that collective consultation don't actually transfer. So if that's the case, who is the incoming employer going to consult with now? Does the incoming employer then have to re-elect reps and start again? What happens if the outgoing employer was happy to negotiate with the trade union, but the incoming employer doesn't want to engage with them post-transfer? Again, the incoming employer needs to work out how it's going to effectively conclude consultation in these circumstances, and the answers could change depending on the context. But it's something that the parties should consider at the outset before the consultation is started, just to think through how that might be managed if it happens. So in summary, the process is complicated and will need careful thought about how it's going to be managed so that it can be conducted in a meaningful way and ensure that the requirements of both consultation processes for TUPE and redundancy can be met. So just to finish up, I wanted to provide some practical tips just about carrying out these processes. So first of all, it's always important to start the planning process early so that you can determine the best way to carry out the restructuring, identifying any potential risks or obstacles and considering how to plan around them and factoring in those minimum periods for consultation. The more time you spend at the outset before the start of the process, working out a timeline and necessary steps and planning communications, hopefully the smoother the process should be, although of course there's always some of those unexpected issues that can arise. It may be possible to cover off some of the risks and apportion liabilities using warranties and indemnities. So in this way, the parties can then agree what responsibilities or actions they agree to undertake. And by using contractual indemnities, they underwrite those liabilities or potential claims that could arise or be caused if either party failed to carry them out properly. If the restructuring is being made at the request of the other party, then it may be appropriate to ask that party to underwrite any risks caused using contractual indemnities. So if post-transfer redundancies of transferring employees from the customer are to be carried out by the supplier, but at the customer's request, because they want to right-size the service, then it may be appropriate for the customer to cover those redundancy costs or claims arising from redundancy dismissals. Or if a buyer requires the seller to make pre-transfer dismissals, it may be reasonable that the buyer takes the responsibility for any costs of consultation or dismissal claims. The parties will need to negotiate the scope and extent of the protections to be given and any actions that the other party agrees to help mitigate those costs. In a similar way, if a decision has been made not to include information about a subsequent share sale in a TUPE consultation, perhaps it needs to remain confidential for market reasons, then the eventual buyer may want to ask for indemnity protection to cover off any subsequent consultation claim that could result. If the pre-transfer redundancy process is being used, the parties can use that cooperation agreement to set out clearly obligations and provide protection for the other party should the other fail to comply with its obligations. It's also usually sensible to work out a communication plan at the outset to make sure that the messaging for the restructure and how it's delivered is consistent between the parties so that no one goes off script. Often, getting the employees' early buy-in to a process will mean it goes more smoothly and successfully. So I think it's fair to say communications are key. And tied into this will be engagement with the unions. If we have got recognised unions, they'll need to be involved from an early stage of any process, as their support will usually help ensure a successful process and reduce the risk of claims. If you're concerned about confidentiality issues or leakage among the workforce before you're ready to share your plans, one option might be a contractual confidentiality agreement to be entered into with the relevant union representatives.
Thank you very much to Hannah and to Karen there for that introduction and overview, but especially for the risks and how to deal with them. And thank you to those who've been submitting questions. We've got just under 5 minutes left, so I think there's time to pick up one on voluntary redundancy. Karen, would you be able to deal with that one?
Yeah, absolutely. Thanks, Siobhan. So the question is, how do you deal with voluntary redundancies in a collective redundancy consultation, especially if they want to leave early? So I think there's two parts to this question. I guess one is whether the voluntary redundancies actually count towards the trigger for collective consultation. And two, I guess the other part is how a request to leave early. So an employee who's volunteered for redundancy wants to leave early. How does that interact with the minimum time periods under collective consultation? So taking the first part, the main point with a voluntary redundancy is that it may still count as a dismissal for the purposes of collective redundancy consultation. And that obviously means that the obligation to collectively consult could be triggered even where all redundancies are on a voluntary basis. So it doesn't get around necessarily the duty to collectively consult. But of course, it does depend on the actual proposal and what prompted the voluntary redundancy request. Because if, for example, you have an employer who wants to make at least 25 redundancies, and they open the floor for voluntary redundancy requests to be made before they implement compulsory redundancies, then any voluntary redundancies made in response to that are very likely to count towards the collective redundancy consultation trigger. But if an employer is carrying out a more speculative exercise, so they just want to carry out a general sort of cost savings exercise without any specific numbers in mind, and they just want to see who might be interested and what sort of savings the employer might be able to make, then terminations made in response to that sort of an exercise may not necessarily count towards the trigger. But because it's not entirely clear cut and there's quite a bit of risk involved in failure to collectively consult, it's usually better to try and err on the side of caution and include it in your count to see if the duty has arisen. In terms of the other part of the question, so what happens if the employee who's volunteered for redundancy wants to leave early? I mean, from a contractual perspective, the parties can agree to reduce the notice period. And that might be helpful for the employer to reduce the employment costs associated with that particular individual. In terms of whether the volunteer can leave before the minimum 30-day period for that's relevant in statutory collective consultation process, there is case law historically which suggests that they could, and that this wouldn't breach the time limit for when dismissals can take effect. But there is actually more recent case law from the ECJ which actually suggests that that approach carries risk, and it could still lead to claims for protective awards. So I guess in terms of practical steps, if there's an employee who's volunteered for redundancy and they want to leave early, probably the most sensible thing to do would be for the employer to seek agreement of the representatives to enable that person to leave before the end of the statutory moratorium period. Because obviously that's not going to eliminate the risk of claims altogether, but what it might help do is reduce the likelihood of a claim being brought because everyone's in agreement. So that would be my views on voluntary redundancies.
Okay, thank you. Thank you very much. That's a very full answer. And I think we need to end there, the questions, but if you've submitted anything, we will come back to you. So thank you again to everyone. Thank you to the speakers. The recording of the webinar today and the transcript will be available on our website too, together with all the other on-demand webinars we've produced for TUPE Club. Just a quick reminder that there will be a short questionnaire pop up on your screen at the end, and we'd be really grateful if you would complete that, as we do take your feedback very seriously and it helps us to plan. So on that point, our next TUPE Club event will be in November, so watch out for the invitation to that, and we hope you can join us then. Thank you.